We didn't talk about this. So distracted. Can't imagine. Well, I can't imagine that. So
I don't want the photos to be like right in my face. I want to get George Bush.
that's all right. You just want to do it from your seat. You just want to do it from your seat. Or you want you can grab the microphone. Yeah, I'll grab the microphone. All right, ladies and gentlemen, we're about to begin. Welcome to Case Western Reserve. We'll begin this program with an opening by the Associate Dean, former Director of the Cox International Law Center, Hiram Chodosh.
Thank you, Michael. I'm Hiram Chodosh, Associate Dean for Academic Affairs here at the Case School of Law, and on behalf of Dean Jerry Korngold and my dear colleagues here at the Law School, it's a pleasure to welcome you in the audience, both real and virtual, to today's special event on the wiretapping controversy. Before I turn this mock congressional hearing over to my colleague, Michael Scharf, I'd like to pause for a minute to emphasize that this exemplary program is just one of the many outstanding achievements of our CASE Global programs. In collaboration with the school's 5 other centers of excellence, the CASE Global programs support an astounding array of research, training, and public service activities involving nearly 30 faculty and hundreds of students here at the law school. Who would have predicted that here in Cleveland that our first-year Global Perspectives course would be entering its 15th year, that we would offer an international concentration of over 40 courses, one of the best summer global justice institutes in Europe, 2 international journals, one approaching its 40th year, 9 international labs and clinics that do dedicated research for each of the major war crimes tribunals, the World Bank, the Department of Defense, and many other significant institutions. That we'd offer opportunities for 3 moot court teams, including the regional champion Jessup team, the Klatsky Human Rights Watch Fellowships in New York and D.C., and the Cox Fellowships that have sent up to 20 students abroad in the summer. Study abroad opportunities from Vietnam to Sierra Leone, an LLM master's program that has educated over 350 foreign lawyers here in Cleveland, and will soon open its doors in Beijing later this spring. The new Indian Fulbright, CASE LLM fellowships, and conferences and lectures that attract just this year over 85 world-class experts on international legal topics. How did we do it? Commitment, funding, and leadership. First, we've been deeply committed to advancing training, research, and service to meet the pressing global justice challenges of our day. Second, funding. The Guns Foundation grant in 1991 and the avid and generous support of our alumni and friends over the last 15 years have sustained these efforts. And third, leadership. A law school could not possibly have two institutional directors with the expertise, energy, and charisma, the likes of Michael Scharf, who directs the Cox Center, and Amos Giora, director of our Institute for Global Security Law and Policy, and a more talented staff in Nancy Cantor and Alice Simon, and a more inspired and committed group of students who will lead their generation of lawyers working on these critical issues in the future. So, deepest thanks to you, and especially to Michael and Amos for pulling this program together. Thank you, Michael.
Thank you very much, Hiram. And now we are about to begin this very innovative mock congressional hearing. We will be simulating the U.S. Senate Judiciary Committee, a committee that just met earlier this week on Monday and heard testimony from Attorney General Alberto Gonzales on this very issue. Surprisingly, the Attorney General refused, and the committee did not require that he be sworn in. Very extraordinary circumstance. That testimony was fairly one-sided. There weren't other witnesses. It was fairly short. So today, we're going to see what the real testimony would have been like had we had a balanced approach and a more in-depth examination of the issue. This actually foreshadows other Senate hearings that are likely to come in the next 5 or 6 weeks. So I think the world is sort of tuned in to Cleveland, Ohio today to see what happens. Well, I will be playing the chairman of the Senate Judiciary Committee, Arlen Specter. To my right will be Senator Ray Koo, professor from Case who specializes in cybercrime and other things dealing with the Internet and Fourth Amendment rights. And he is from the great state of Ohio. To his right is Senator Jesse Hill, representing the state of New York. Professor Hill was an ACLU litigator in New York City before she came here. We'll bring interesting insights from that point of view. You've already met Senator Hiram Chodosh. I'll put you out in California, I guess. He has no connection with California. That's a random assignment. And next to, at the far end, is Senator John Adler. Professor Adler is a constitutional law professor here. He's nationally known for his work in constitutional issues, and he'll be representing the state of Pennsylvania. And the person I just skipped over, I did so on purpose. He is co-sponsoring this event. It is Senator Amos Giora from the state of Michigan. How about that? I know he's a real fan of the University of Michigan's teams. And he is going to introduce the two expert panelists that we've brought from Washington, D.C. to make this a really exciting and interesting event. Amos?
Thank you, Senator Scharf. We begin with Professor Ruth Wedgwood. It is an honor to have you with us today. She is a very distinguished professor at the Advanced International Studies program at Johns Hopkins. I've had the pleasure of appearing on a panel with her. Thank you for joining us. Her co-debater is Professor David Cole from Georgetown University. Professor Cole has been called by the journalist Anthony Lewis one of the great liberal voices in America today. Professor Cole, also a pleasure to have you with us today.
Thank you. All right. Now, the ground rules for this Senate hearing are as follows. We will begin with a 15-minute presentation from Professor Cole, followed by a 15-minute presentation from Professor Wedgwood. Then each of the senators, in the order that we are seated, will grill the expert witnesses, and we have 5 minutes total for our questions and answers. The witnesses should try to keep their answers fairly short so that we can ask some follow-up questions. And then after that period, there will be a half hour of Q&A from the audience, but this will be a simulated press conference, and you get to represent the national media. We actually do have members of the media with us today. Maybe they'll take the lead and show you how it's done. Without further ado, let's begin the hearing with the presentation of Professor David Cole.
Thank you, Mr. Chairman. And let me make a few opening remarks about how this is different from a real congressional hearing for those of you who haven't spent as much time in Washington as I have. The first way in which this is different from a real congressional hearing is that the senators are actually all present. In most hearings, at least those that I've testified, right, and most of them that I've testified at, by the time I testify in an event, there might be one senator left, and otherwise it's staff members, and you talk to an empty banquette. So I'm grateful to have you all here. The second way in which this is different is that we're now 10 minutes into the program, and you're actually hearing from the witnesses. In a usual Senate hearing, you first have opening statements by each of the senators, which is the most important part of the hearing, where they get to pontificate for 10 minutes or so that they get their sound bites in. And the witnesses are merely a prop for the senators. So this is I would say, an improved version of the Senate committee hearing. Let me begin by saying what this debate is not about and what this hearing is not about. And I think it's not about, ultimately, the question of whether the president should be listening in on phone calls by al-Qaeda and members of supporting or affiliate organizations. It's not, I think, about the issues of privacy and Fourth Amendment for the most part, for a couple of reasons. One, we don't know the scope of this program at this point, and so it's hard to make judgments about whether its scope violates or trenches upon Fourth Amendment privacy concerns. Two, I think most Americans and probably most senators agree that we should be listening in when al-Qaeda calls. So there's not any dispute about that. And in addition, the Foreign Intelligence Surveillance Act, the statute at issue here, does not prohibit the government from listening in on any call made by a member of al-Qaeda from outside of the United States. As long as the surveillance is targeted at the al-Qaeda member outside the United States and the information is acquired through a tap outside the United States, there is no law that limits the president in any way, shape, or form from collecting that information. So it is a red herring when the defenders of this program say, well, shouldn't we be listening in to members of al-Qaeda? That's not what the debate is about. So what is the debate about? The debate is about whether we should be doing that pursuant to the law or whether we should be doing it pursuant to executive fiat under an understanding of the Constitution that allows the president to order that federal statutes be violated in secret. It's a debate about the scope of the commander-in-chief power. It's a debate about separation of powers and checks and balances. That's what is ultimately at issue here. So let me set the stage briefly by describing the Foreign Intelligence Surveillance Act, what it does not do, and then turn to the two asserted bases, both, I think, fundamentally flawed for the asserted legality of this program. The Foreign Intelligence Surveillance Act was enacted in the late 1970s after a committee, a special committee of Congress called the Church Committee, revealed massive, widespread violations of Americans' rights by surveillance conducted by the National Security Agency, by other agencies, on thousands and thousands of innocent Americans. The response was to say, let's regulate the gathering of foreign intelligence information. We regulate it by passing a law enacted by Congress, signed by the President, which permits foreign intelligence electronic surveillance for national security purposes, but requires that in most cases the President must go to a court and make a showing that there's a justified basis for gathering that electronic surveillance, namely probable cause that the individual targeted, if it's a U.S. person within the United States, is an agent of a foreign power or a terrorist organization. You don't have to show crime. You don't have to show probable cause of criminal activity, just probable cause that the person is connected to the terrorist organization. Congress sought to make clear that this was the way to do it. They provided in 18 U.S.C. Section 2511 that this is the exclusive means by which electronic surveillance may be conducted. They went further in Section 1809 of the Foreign Intelligence Surveillance Act and said it's a crime to conduct foreign intelligence beyond the scope, conduct electronic surveillance beyond the scope of this exclusive means. And this is the most important point, they specifically addressed the question of authorization during wartime. Under Section 1811 of the Foreign Intelligence Surveillance Act, they provide that when Congress declares war, the President shall have 15 days to conduct warrantless wiretapping. And the idea was, and they specifically set this forth in legislative history, if the President needs more authority to conduct warrantless wiretapping, he can come to us and ask for it, and we can amend FISA to give him that authority. But 15 days and no longer if he doesn't come to us and ask for further authority. Now, in this instance, the President decided, in the face of that statute, a statute says this is the only way to do it, it's a crime to do it in any other way, and if you want broader authority, come to us and seek an amendment to FISA. The President decided not to come to Congress, not to seek an amendment to FISA, instead to order in secret that conduct that is criminal on its face go forward. What is the administration's defense of the program? They have two. The first one is frivolous. The second one is extremely dangerous. The first one is that Congress somehow, without saying so, in authorizing the use of military force against al-Qaeda on September 14, 2001, somehow implicitly overrode FISA and gave the President unlimited authority to conduct warrantless wiretapping of Americans. That argument is frivolous, I suggest, because when you put the authorization to use military force, which says not one word about warrantless wiretapping, up alongside 1811, the provision I referred to earlier that's titled Authorization During Wartime, it's clear that the authorization to use military force cannot provide the authority that the government suggests that it does. Why? Because if Congress says that even when we declare war, a more serious and grave step than authorizing the use of military force, you get 15 days and no longer, how can it be that when they enact an authorization to use military force and don't declare war, you somehow get unlimited authority to conduct warrantless wiretapping? In addition, when Alberto Gonzales was asked, why didn't you go to Congress and ask specifically for this authority, he said, well, we talked to some members of Congress about doing that, and they said it would be difficult, if not impossible, to get it. So they didn't go. Now, he later sought to backtrack and say, well, what I really meant was it would be difficult, if not impossible, to get it without compromising the program. But the point, the critical point here is they thought about going to Congress and asking for it and decided not to. How can you argue, on the one hand, we didn't go to Congress and ask for it because we were concerned that we couldn't get it, but on the other hand, Congress gave it to us without ever having said so? That's the frivolous argument. The dangerous argument is the backup argument that the administration relies upon, and that's the commander-in-chief authority. And here the argument is that FISA is unconstitutional to the extent that it restricts the president as commander-in-chief in gathering signals intelligence on al-Qaeda. And the reason for that is that the commander-in-chief authority, the government argues, the president argues, gives the president uncheckable authority to choose the means and methods of engaging the enemy. Those are the Justice Department's words, the means and methods of engaging the enemy. And the claim is anything that falls within that paradigm, means and methods of engaging the enemy, cannot be restricted by statute. All right? And therefore, to the extent that the Foreign Intelligence Surveillance Act says you can't wiretap Americans in the United States without justification, without going to court, because that interferes in the president's mind with engaging the enemy, it's unconstitutional. Now, to me, this is a resurrection of the Nixon doctrine. Richard Nixon famously argued in defending a situation in which he authorized illegal warrantless wiretapping of Americans during the Vietnam War. He argued, if the president does it, that means it's not illegal. Now, President Nixon learned that that is not the American doctrine. That was President Nixon's doctrine. That was part of the articles of impeachment. He ultimately was forced to resign. President Bush has essentially resurrected the Nixon doctrine with one modification. He says, if the president does it and says the magic words, commander-in-chief, it's not illegal. Now, what's wrong with this argument? Well, first, let me say this is not the first time the president has made this argument. The Justice Department made this argument infamously in arguing that the president could violate the criminal ban on torture in the August 2002 torture memo. The president asserted this same argument, the same authority, in his signing statement affixed to the McCain Amendment, which was recently enacted by overwhelming majorities in both the Senate and the House, which prohibits the use of cruel, inhuman, and degrading treatment. The president says, I'll enforce that consistent with my authority as commander-in-chief, meaning except where I decide not to enforce it. And the president made this argument in the Guantanamo cases to the Supreme Court and said that it would be unconstitutional for the court to extend habeas corpus judicial review, a statute affording judicial review, to the Guantanamo detainees. Why? Because that would impermissibly intrude on the commander-in-chief's uncheckable power to engage the enemy. The problem with the argument, the Supreme Court rejected it. In the Razul case, the Guantanamo case, all 9 justices rejected the argument. 6 justices held that the statute extends, and judicial review and congressional limitation do apply to the president's treatment of enemy combatants. And 3 justices dissented, but they said, we just read the statute differently, but Congress certainly could, if it wanted to, extend these limitations to the president. Similarly, the court in the Hamdi case involving the U.S. citizen enemy combatant rejected a similar argument that constitutionally the courts could not review the factual basis for the president's designation of a U.S. citizen as an enemy combatant. The Supreme Court in the Youngstown sheet and tube case in 1952 rejected the same claim when President Truman made it to justify the seizure of the steel mills. The Supreme Court in 1804 rejected the same claim in the Little versus Bareem case, in which the president asserted that he could order that ships coming from France be seized when Congress had only authorized that ships going to France be seized. In fact, no case has upheld the startlingly broad assertion of authority that is at the bottom of President Bush's order in this case. But then again, I suppose, what are a few negative Supreme Court decisions when, in your view, it's the president, not the Supreme Court, who has the power to say what the law is? Thank you very much.
Well, it's a pleasure to be here and to meet my good friend David Cole again on another issue. We are, I think, just for clarity, doing, to some degree, a mock hearing, so we don't necessarily believe everything we say, but we must think, as intelligent human beings, that they're colorable arguments. I will believe most of what I say. I think everything, probably, but there is a proviso that since this is an issue where we are all working through the problems and the thought and the quixities of it, that it's going to take, I think, a while for the country and probably any good faith person to come to a final moment of resolution on the bottom line. But let me bring to your attention several things that David has perhaps neglected to emphasize. And partly this is a problem you have to approach in a Rashomon fashion. Which end of the elephant do you start with? But the difference now from 1978, when I shortly thereafter had the pleasure of being in the Carter Justice Department, is that there are problems we didn't ever suppose that we'd face. I mean, Americans clearly have very, very high expectations of privacy. That's why, as a last, I worked on FBI guidelines with Judge Webster and Attorney General Griffin Bell. Americans want to know that they're safe in their homes and can have a rich, autonomous private life that nobody can intrude on. But at the same time, in 1978, we weren't thinking about anything like Al-Qaeda, a cyber entity that began to mimic the powers of a nation-state in a situation where deterrence has failed, the second strike capability that kept, faute de mieux, the U.S. safe in the Cold War, where if the Soviets attacked us, they knew we could retaliate against Moscow or military targets near Moscow, and therefore, thank goodness, nuclear weapons were never in fact used, and everybody had a great sense of caution about them. A different enemy in the sense that it's not an organized nation state, and you don't know its address. You don't know who its players are. You're not watching the front door of the Soviet embassy in a way that you can identify everybody who's likely to be a Soviet agent. you really face a very different kind of circumstance, an adversary that doesn't itself follow the rules of war, which attacks civilians deliberately, which I think all of us would agree is a form of terrorism and a kind of war crime. And really a technological change. Again, we are old enough, but we date ourselves, to not have always had handheld computers or laptop or desk computers. And the kind of capacity, dare one call it agility, that an adversary may have when it can really use electronics in a fulsome way is something that really wasn't contemplated in 1978. Now, what's wrong with FISA? FISA was, in fact, a very, very good faith attempt to capture what was thought to be needed by the executive at that time and place. It followed a period when, in fact, there had been abuses. No one wants to go back to the period of using foreign intelligence powers or domestic intelligence powers for political purposes, whether it's LBJ or President Nixon. White House incumbents were often too easily tempted to make use of their powers for purposes that weren't worthy. But FISA does a couple of things. It tries to capture what you might need tactically and strategically against your adversary. It uses the probable cause standard, which you're familiar with from criminal law. But it's not probable cause to believe that a crime is about to be committed. It's probable cause to believe you're an adversary. Nobody, even in criminal law classes, can quite capture what probable cause means. Is it 50%? Is it 33%? It's certainly not 1%. And that may begin to give you a sense of the conceivable problems that it would pose in regard to catastrophic harm by an unidentified adversary. 1% chance that somebody might be intending to explode or hide a radiological bomb or a nuclear device. You don't get to multiply the percent times the harm when you're determining the nature of probable cause. Yet, FISA uses just that standard of probable cause, which is hard to meet. David has never had the pleasure of working as a prosecutor. The problem that prosecutors find the first day on the job is that if you need PC to get PC, how do you get PC? Probable cause does not grow on trees. You have to know a lot about a person before you can generate the probable cause that you need to get a wiretap. And you sometimes do it in ways that have escaped the attention of the Supreme Court, whether it's gathering garbage on the curb or talking to their friends who give you voluntary interviews. But there often are cases where you can't go forward because probable cause is a significant threshold requirement. And it really is much more than a hunch, an intuition, a belief, or even a well-founded belief, but one that only rises to, say, 2, 5, or 10% probability. Now, again, in this other situation of wartime, even low probabilities of catastrophic harm might seem to you to be unacceptable. FISA protects several classes of people, and then think about how these would work out in practical terms. It covers any kind of intentional targeting of a known U.S. person. If the communication comes from abroad or goes abroad, and a U.S. person is a citizen or a permanent resident alien. It also protects any interception of a communication of any person in the U.S. If the acquisition occurs in the territorial U.S. So say if you had two people who snuck in over the Mexican border are illegal aliens, have only been here for 24 hours, and they're communicating within the territorial U.S., nonetheless, FISA would plug in. And it also covers any kind of physical intrusion, sort of either a black bag job or a room bug that's in the U.S. Now, let me give you a couple of instances where I think this could raise problems. And we don't know for sure, well, actually we do know. We know much more now than we did a week ago about what the government says this particular program was about. But let me give you one example that goes beyond what's been stated in the hearings that would trouble me. This has to do with a skipping stone. You might well want to follow a communication that al-Qaeda sent from abroad, from Afghanistan, to Chicago, and then followed to Cleveland, and then to New York, and then to Miami. You might want to know, simply by the frequency and periodicity of who's calling whom, what might be the likely network or spider web of people who are associated with Al-Qaeda. But under FISA, if you apply FISA strictly speaking, you couldn't follow that skein any farther than the first communication from Afghanistan to Detroit. And the question would be, does a president, if he's acting in good faith, if it's your president, David, the guy you vote for next time, President Clinton Part 2, whoever, would you want to allow that president, whom you like, whom you trust, to follow that spiderweb skein? Or would you want it simply be limited by the statutory provision of probable cause and take your chances on the consequential damages? You're going to have situations where communications that formerly weren't covered are newly covered because we now have a different technology where you are now using broadband technology, fiber optics, where the acquisition will technically be in the U.S., whereas 25 years ago, the method of communication and therefore the acquisition point would have been outside the U.S. Because of the technological change, with no change in the personality of the actors, things will now fall under FISA that formerly didn't. Now, the case that Attorney General Gonzalez was talking about in his later descriptions were phone calls where one member of the conversation is associated with Al-Qaeda and where one end of the conversation is abroad, either calling or receiving. In regard to communications that deal with border boundaries, think back to the original idea of what the Fourth Amendment would protect. Fourth Amendment's meant to credit and cherish reasonable expectations of privacy. When you go across a border, your bags are searched. Of course, you're searched for the airplane. When your packages are sent in or out, they can be searched. If you're looking at what kind of expectation of privacy you have, the fact that it involves foreign territory may be very, very pertinent to the sense of whether there is a constitutional violation or not. Now, one complaint that's made is if you have any quarrel with the techniques or technical details of the FISA Act, go to Congress, ask them to change it. That may well be a possible means. It's also true, however, as LBJ taught us, as he said, counseled Martin Luther King, legislative moments are very hard to come by. At times that are anywhere near an election cycle, people get into very polarized positions. People can't be seen talking to each other. So you not only have the problem that a legislative change might, in fact, reveal details of the program, but it may well be that because of the, if you will, the ambition of political parties to save issues for elections, that they may not be prepared to address it yet. And one example that actually comes from the 1970s, an old civil liberties intelligence hand told me this story. It was known in the mid-70s that the government from time to time would engage in so-called black bag jobs, physical searches of people thought to be foreign agents. And yet that was not added to the FISA Act when it was passed in 1978. And one account is that some people thought if you put it in the statute it would happen too often. Therefore leave it on the simple justification of executive power, hoping that that would induce a kind of caution. That was a critique from the left. They didn't want it, I'm told, in the statute because they thought it would be used too frequently. And yet they knew of the problem. Congress was not willing to address it at that point. Now, you all are law students, so you have come across the phrase occupation of the field. Have you ever heard that funny phrase? When Congress passes a statute, should you suppose that they mean it to be the exclusive method of doing something, whether it's federal versus state or congressional versus executive, occupation of the field? I do think that when you look at a statute, under changed circumstances in particular, you have to entertain the idea of a dynamic occupation of the field. It could be that in 1978, Congress meant the FISA statute to be the only way of getting a foreign intelligence wiretap. But the question you ought to ask is, would Congress have meant that if they knew the changes that they would face vis-a-vis technology, the kind of adversary, the kind of use of the Internet? And that's a much harder question to answer, I think. We have dynamic interpretations of many, many statutes. We have dynamic interpretations of the Constitution. The Air Force is not unconstitutional, even though it's not mentioned in Article 1, Section 8 of the enumerated powers of the Congress, because we reasoned that Congress would have wanted to have an Air Force if they had known that Leonardo's dream of flying would ever have come to pass. So we read it into the Constitution. And the same thing is true of theories of occupation of the field. The other question you might ask yourself, a kind of a functional question, what would you have a court do if, in fact, the way you determine that somebody is an associate of al-Qaeda is to look at the most recent, updated, dynamically gathered data that you have on how al-Qaeda members tend to act? How do they make their phone calls? Are they using a switchboard in Kandahar? Has it moved to Yemen? Has it moved to Mongolia? Has it moved to Somalia? How many phone calls do you have to have before you know something is a switchboard? That can get you very deep into the tradecraft of intelligence. Now, in the case of criminal law, we have courts and judges as the gatekeepers in almost all circumstances because they do criminal law for a living. But judges in general, even FISA judges, don't do intelligence in quite the intense way that courts take care of criminal law enforcement. Let me just note two other things, if I will. David would have you believe that theories of robust executive power are peculiar to a particular president. That's simply not true. Read the famous Trong case from 1980, Fourth Circuit. The Trong case is otherwise famous for saying that before certain changes, a FISA wire had to have as its primary purpose the acquisition of foreign intelligence and could not have a ambiguous double purpose of criminal law enforcement and intelligence. But the Trong court also said the following: the separation of powers requires us to acknowledge the principal responsibility of the president for foreign affairs and concomitantly for foreign intelligence surveillance. The needs of the executive are so compelling in the area of foreign intelligence, unlike the area of domestic security, that a uniform warrant requirement would unduly frustrate the president in carrying out his foreign affairs responsibility. More importantly, the executive possesses unparalleled expertise to make the decision whether to conduct foreign intelligence surveillance, whereas the judiciary is largely inexperienced in making the delicate and complex decisions that lie behind foreign intelligence surveillance. The courts are unschooled in diplomacy and military affairs, a mastery of which would be essential to passing upon an executive branch request. Then you might also look at a OLC opinion, the Office of Legal Counsel, from the year 2000, when President Clinton was still in office. And this had to do with whether the president could ever demand that the criminal law enforcement authorities turn over to him information that was gathered in a criminal wiretap, even though ordinarily Title III criminal wiretaps are kept secret. And the OLC opinion, written by one Randolph D. Moss for the Office of Intelligence Policy and Review, said the following: the Constitution vests the president with responsibility over all matters within the executive branch that bear on national defense and foreign affairs. Where the president's authority concerning national security is in tension with a statutory rather than a constitutional rule, the statute cannot displace the president's constitutional authority and should be read subject to an implied exception in deference to such presidential powers. We believe that if Title III limited the access of the president and his aides to information critical to national security or foreign relations, it would be unconstitutional as applied in these circumstances. One point about the authorization for the use of military force that David has failed to mention is it shows we're in war. And in war, the president can not only capture people who are combatants, he ought to be able to overhear them. And this has nothing to do with COINTELPRO or broader theories of intrusion, but if you're fighting a war on an American battlefield, you do need some signal intelligence capability, and a court is not necessarily the place that can conduct that in the volume or with a speed that you need to be effective in thwarting a real-time attack that can have truly catastrophic consequences for innocent civilians. Thank you.
All right, we'll begin the questioning. Thank you very much.
That also doesn't happen in congressional.
We'll begin the questioning again. Each senator has 5 minutes for questions and answers. We have a timekeeper there, and we will scrupulously keep to that timekeeper. Let me begin with a question for Professor Cole, and beginning with the assumption that the FISA statute allows for unwarranted wiretapping if it is authorized by Congress. You had mentioned this Supreme Court case of Hamdi versus Rumsfeld. And in that case, the Supreme Court recently ruled that the post-9/11 authorization to use military force had authorized the president to detain a U.S. citizen in the United States because, quote, detention to prevent a combatant's return to the battlefield is a fundamental incident of waging war. So 5 Supreme Court justices concluded that the post-9/11 authorization statute, quote, clearly and unmistakably authorizes the fundamental incidents of waging war. My question to you, Professor Cole, is why wouldn't communications intelligence targeted at the enemy be a fundamental incident of the use of military force?
I think it is, but I think here's the difference. In Hamdi, the court was faced with an authorization to use military force, and no competing specific congressional directive on the question of detaining American citizens as enemy combatants during wartime. In this context, the court would be faced with the same authorization to use military force, which says nothing about wiretapping. But here, unlike with respect to detention, you have a specific directive from Congress that says this is the authority we are going to grant during wartime, and it's 15 days and no longer. Now, I would posit that had there been a statute on the books that said when war is declared, the president can detain American citizens as enemy combatants, but only for 15 days. And if he needs greater authority, he should come to us and ask us to amend this statute. There is no way that the Supreme Court would have read the broad and unspecific authorization to use military force to somehow override that very specific statute. The rule is that a specific statute governs over a general statute in every circumstance. The situation with respect to detention was there was no specific statute governing wartime detention of American citizens as enemy combatants. Here, there is a specific statute, and I think that makes this an entirely different situation.
All right, I will then move to the next of our congressional panel, and that's Senator Koo.
Thank you, Mr. Chairman. Thank you both for being here and testifying before us. Professor Cole, I'd like to start with you and ask a question that I think many of us are curious about. And it goes along the lines of even if one does believe that what the President has done here has violated both provisions of FISA and therefore run into constitutional concerns over the separation of powers doctrine, as well as potentially violate the Fourth Amendment and the probable cause and warrant requirement required by the Fourth Amendment, what's the remedy here? I mean, we're not talking about an exclusionary rule solution in which the evidence that's gathered here will be excluded in the trial of these individuals, nor are we not necessarily talking about a civil action under Section 1983 for damages in most of these instances. So what can Congress and what can the American people expect in terms of a remedy for this problem?
Right. I think that's a great question. My view is that what is important is that at the end of the day, we restore the notion of checks and balances that we had before the Bush administration came to power. And that is ultimately what's most critical here. The way in which the checks and balances are restored is less critical. So, for example, one way in which checks and balances could be restored is a censure of the President for violating a criminal statute and ordering that a criminal statute be violated in secret. I don't think that without knowing anything more, impeachment is appropriate or prosecution is appropriate, but censure, I think, would be appropriate. It would be a way for Congress to assert the importance of checks and balances. Another way of responding might be to cut off funds for this program if Congress determines that the kind of surveillance that is being conducted should not be conducted. and if it determines that some narrower form of surveillance, but broader than FISA, is appropriate, then it should amend FISA to authorize that. But I think the important point is that Congress must assert its prerogative here, just as it did just a month ago in the McCain Amendment, when it learned that the President had ordered in secret that the Torture Convention be interpreted in such a way that he could impose cruel, inhuman, and degrading treatment on anyone who didn't have a U.S. passport. Congress responded by making it absolutely clear that he could not exploit that loophole. And the President, despite threatening to veto it, despite sending the Vice President over to try to get an exception, was forced ultimately to sign the bill against his will. That, I think, restored some notion of congressional role.
Mr. Chairman, since we're both sitting here at the witness table, can we reply to each other's
I
remarks?
think the chairman will exercise his prerogative and allow you to have a minute of rebuttal there.
Thank you. Well, not rebuttal, but rather demur, I suppose. Dismissal is irrelevant, if you will. David, Mr. Cole, my worthy adversary, has conceded in his opening remarks that the interception of any communication to or from a person who is a member of or associated with al-Qaeda is constitutional and is consistent with FISA, at least the evidentiary standard of FISA. So the only complaint seems to be that this was done not because it was not that this was a wrongful search in and of itself, but that the President didn't go to the FISA court. He's not saying that this kind of search violates the Fourth Amendment. He's simply saying that you had to go to Judge Catelli or someone else in the FISA court and ask for the warrant. So I would find it most peculiar that David would want to shut down the program or censure the President or cut off the funding when it's just the kind of search he thinks in substance is permissible and, frankly, surely necessary for national defense.
And if I could respond briefly, that's playing with words, because no one would accept an argument from a police officer, well, I actually had probable cause, so the fact that I searched the house without getting a warrant means that it's constitutional, because I would have gotten a warrant if I'd gone to the judge.
You don't have to get a warrant.
That is not, that is, no,
Here, let's have order in the Congress.
That is not a defense to the violation, number one. Number two, we don't know the scope of this program, but if the scope of this program were simply listening in abroad on al-Qaeda members' calls, the President would not have had to make the frivolous and dangerous arguments that he has made, and the only arguments he has made, which, interestingly, Ruth has not defended here today, because he could have simply said, the Foreign Intelligence Surveillance Act doesn't cover this, and so I'm authorized to do it. There would have been no controversy had that been the scope of the program. So by definition, even though they haven't told us what it is, the very fact that they feel compelled to make this broad assertion of unchecked executive power and to make this ridiculous argument that Congress somehow gave them without saying something that it specifically denied them in 1811, suggests that they are doing more than simply listening into members of al-Qaeda.
I think we need to move on to the next senator, who is the Honorable Jesse Hill, and the chair gives you the floor.
My question is for Professor Wedgwood. So as I understand much of your testimony today, you're suggesting that FISA is essentially, in many respects, out of date. It doesn't, the conditions in 1978 do not match the conditions that we're facing today, and that the President, therefore, might need to exercise his powers to essentially, as Professor Cole just suggested, ignore or overstep FISA. And of course, the natural response, as you mentioned, would be, well, why doesn't Congress simply amend FISA if it's out of date? And as I understand your response to that, it's, well, that's hard, essentially. And again, that this is wartime and that the President needs to act. I'm wondering whether there's any authority or any Supreme Court case in particular where the executive power to act in the face of explicit congressional disapproval has been upheld, and particularly, as Professor Cole pointed out, in the face of a criminal prohibition.
Well, the Clinton administration itself, again, hewed closely to the view that the president has an authority to not follow statutes that he in good faith believes to be unconstitutional, and that one president doesn't preclude another president in that view simply because he's signed a statute. But I think, again, you don't have to go there, is my point, because a reasonable construction of what Congress meant in 1978 was not to preclude every other contingency of changed technology, changed adversary. You have to read Congress's intention reasonably. Secondly, the problem with seeking a one-time congressional fix is that statutes are extremely public. They have to be public. And what the Federalist Papers do teach you about the need for dispatch and secrecy in the executive is partly because of the absence of our favorite phrase of acoustic separation. You can't announce it to the public and the Congress when the adversary is listening as well. So if Congress was to try to specify what algorithm would be sufficient to conclude that somebody is associated with al-Qaeda, clearly you wouldn't want al-Qaeda to know that, or they would wear a different color tie, or they would make fewer than 7 phone calls to an al-Qaeda headquarters. They'd find ways of engineering around whatever was your factually specific predicate. And the idea of giving this simply to judges, yes, it's true that the FISA court has, over time, I think, recruited a number of judges who were interested in intelligence and gained some expertise in it. But when you have an adversary who really is like quicksilver, agile doesn't begin to describe the capacity for camouflage, embedding communications in a internet image. The method of characterizing how you know somebody is a member of al-Qaeda is quite difficult to capture in any one-time circumstance. And secondly, I will quarrel on principle with the idea that it has to be criminal probable cause. Because if you are going to require a 30 or 40 or 50% probability that somebody is associated with al-Qaeda before you can tap them, that means a 5 to 10 to 15 to 20% bad guy who is intending extraordinarily harmful measures that would affect thousands of people would be beyond your ken. And in wartime, that would be a heck of a way to operate as a commander-in-chief.
And if I could just follow on that, and tying it perhaps back to this question of remedies, should the information that is gathered in these wiretaps be able to be used to support applications to the FISA court and or to be used in criminal cases? And if so, is that undermining in any way Congress's intent?
Well, so far they haven't been. The Bush administration has represented to the FISA court that it's not using any kind of off the FISA method of obtaining information in order to put together FISA probable cause. If it were, there's been a big debate again about the wall vis-a-vis criminal versus intelligence. Much chagrin. There's a lot of chagrin, if you will, on a number of sides, but the chagrin that the inability to integrate everything you know, to collect the dots so you can connect them, was deeply burdensome in the attempt to safeguard before 9/11. And the maintenance walls at the moment are in very bad odor, not simply in Berlin, but in Washington, because it's hard enough to keep up with a quicksilver adversary. And the inability to integrate criminal and intelligence collection methods has been a real detriment in the past. So one would have to think very carefully through that problem. You don't want to obviously have methods used as an evasion of Fourth Amendment standards that otherwise apply. If you're really going after a coke dealer, you don't want to be using either FISA taps or non-FISA intelligence taps. But the problem of segregating purpose is also a difficult one.
Thank you.
Senator Giora, the floor is now yours.
Thank you, Mr. Chairman. Professor Wedgwood, we've been down the road of an unfettered executive many times in American history, and each time it has been an utter failure. The FISA amendment allows for a 15-day warrantless period. In many ways, it strikes me that what you're suggesting is allowing the executive, once again, this unfettered power. The question is whether, in the context of separation of powers, that's something that we can truly live with, particularly in this very tenuous age that we're all living in.
Well, I think it may depend in part on the kind of issue you're speaking of. Again, presidents going way back have had aides who they later came to regret, and actions they've come to regret. But in the regard to privacy, this doesn't have to do with the physical integrity of the body. It doesn't have to do with torture or cruel and inhuman and degrading treatment. It's not a entitlement that's even mentioned in the International Covenant on Civil and Political Rights. If you look at state practice, many European countries have utterly unregulated intelligence intrusions. We are unusual in the extreme in having this kind of statutory regulation of intelligence surveillance. So I do think that when you're thinking about the dangers of abuse versus the importance of avoiding other kinds of abuses, like the abuse of losing 10,000 citizens or 100,000 citizens, that the kind of value that's at stake has something to do with the issue. There are other ways, as John Hart Ely instructed us, of providing checks and balances. Clearly we have a very robust press, and the fourth branch of government. Often when people are troubled by something, it usually comes to light. But I don't think that you can treat this, if my friend David Cole is critical of a unitary theory of the executive, I would be equally troubled by a unitary theory of the counter-executive. You have to take it issue by issue in the practical circumstances that you're facing. And in wartime, and this is in every real sense of the harm, of the danger of catastrophic harm, it's wartime. And in that circumstance, the idea that Franklin Roosevelt would have let a federal judge tell him who to target, or that even Congress could tell you who to target, would be dismissed. The commander-in-chief authority does mean something. Even state governors, as we know from Article 1, Section 10, have war powers when there's imminent harm that does not admit of delay. So I just don't think you can go back to the founding of the Republic and dismiss the real practical concerns that are here by citing opinions pro or con of Woodrow Wilson or Abraham Lincoln's suspension of habeas corpus. I wouldn't mix my apples and my oranges in this. You don't, and finally, you don't have to subscribe to a unitary theory of executive power to suppose that in some circumstances the executive does have plenary power.
And I do, to Professor Cole. When you think about balancing in the context of the situation we're in, how do you see the balance between, if you will, the courts and the presidency?
I think that the approach that Justice Jackson put forward in the Youngstown Sheet and Tube case, and which has been seen as really the guiding approach to separation of powers since that time by the majority of the court, is the appropriate way to look at this question. And that is, if the president acts with the support of Congress, then he's acting at his highest level of authority, and he can go forward. If the president acts where Congress has been silent, then you're in a twilight zone, and generally the president with the ability to engage in the initiative is going to be upheld. But where the president acts in contravention of specific statutory dictates, he's acting at his lowest ebb, and he can only take action contrary to Congress if Congress has no power to regulate the subject, So how does that apply here? Well, Ruth referred to the Trong case and very broad statements in the Trong case about the president's inherent power to conduct electronic surveillance. What she didn't point out is that when the Trong case was decided, it was talking about the president's authority before FISA was enacted. Before FISA was enacted, there was a statute that specifically recognized that the president has inherent power to conduct foreign intelligence electronic surveillance. So Congress had approved of the president's engaging in warrantless electronic surveillance. He was at his highest ebb, therefore, and the court, not understandably, said that that would be constitutional. When FISA was enacted, Congress repealed that provision and instead said, now we're setting the rules here. This is the only way to do it, and it's a crime to do it in any other way. Ruth suggests, well, that's what they said in 1978. The times have changed. Maybe they don't mean it anymore. Well, that argument, I think, ignores the fact that Congress has amended FISA 5 times, including in 2001, right in the Patriot Act, including in 2004, and never took out this directive that its exclusive means. So then the question is does Congress have power to regulate the subject of electronic surveillance of Americans at home? And I think the answer to that is clearly yes, under the Commerce Clause, under the Foreign Commerce Clause, with respect to the NSA, under its power to issue rules and regulations governing the Army and Navy, because the NSA is part of the military. And therefore, Congress clearly has authority to act here. Now, it may well be that there is some residual power that the Commander-in-Chief has that Congress could not override. I think, for example, if Congress sought to put the authority to run the war in some other official outside of the chain of command, that would violate the Commander-in-Chief authority. But the notion that Congress cannot limit electronic surveillance, warrantless wiretapping of Americans at home simply because the President is fighting a war, I think is a radical notion and one that is not supported by a single case we don't have to go back to the views of the framers, but not a single case from the time of the founding of the Republic to today holds that the President can violate a criminal statute even when exercising Commander-in-Chief power. And, as I said in my opening remarks, the two most recent Supreme Court decisions on point, Hamdi and Razul, both squarely rejected that notion in the context of detention, which, if anything, is a fundamental incident of the war power. It's detention of the enemy combatant. And yet, the Court said Congress can act to limit the President's power, and the courts can act to review the President's exercise of that power.
If I may, Mr. Chairman, just to use my unfounded prerogative one more moment.
Very brief.
Number one, FISA covers much more than Americans at home. Anybody who's territorially in the U.S. The 20 hijackers, or 19 hijackers, in the U.S. were covered by FISA, which means that you may have combatants here who are foreign nationality, foreign domicile, who have the benefit of being protected by the FISA court. Clearly, there are some parts of executive power that couldn't be trampled on by the Congress. If the Congress had said in World War II that when FDR was targeting a Nazi submarine, because they were concerned about the possibility of damage to whaling and the future of the whale population in the North Atlantic, that you'd have to go to a court and have a court evaluate the predicate for knowing it was a Nazi submarine versus a whale, surely that would be seen as an invasion of the Commander-in-Chief power, even though Congress has a valid interest in sustaining the whale population. So David has to admit that in some circumstances, the Commander-in-Chief power not only has implications vis-a-vis Congress's power, but the inappropriate use of Article III courts. You should think about the limits of Article III as well as the limits of Article II.
Senator Chodosh, you now have the floor.
Let's say that we concede that FISA is outdated and that legislative moments are few and far between, but let's also think that we're currently in a legislative moment in the wake of this controversy. Professor Wedgwood, what would you suggest be the primary amendments to FISA to make it work more effectively? And then, Professor Cole, if you could comment on those suggestions and see which ones you would be willing to accept.
Well, that's a hard question because, again...
That's why I posed it.
No, it's epistemologically hard because what has been said by the administration is that there's one program which consists of phone calls to or from persons associated with al-Qaeda. And I think it would be a very long debate in the Congress to figure out how you characterize the necessary predicate. I mean, our whole vocabulary in issues of searches and seizures comes from criminal law, where we have the word probable cause, we have the word reasonable suspicion, we think about Terry stops, but we've never had to even think about this before in circumstances of truly catastrophic harm. So I think you would have to reopen and have a very long debate about probability versus harm. Would a 1% chance of 1 million people's death be sufficient as a predicate? 1% chance he's al-Qaeda, 1 million people. This would not be an easy debate. The second problem is that to make it fit what could be necessary iterations of search procedures, might require many legislative moments. Third problem, I've never known a senator's staff to leak anything, much less a senator. But the rule in Washington is a true one. If you tell more than about a dozen people, it's in the Washington Post the next day. It just happens. And the difficulty with getting a tightly fitted statute, quite apart from what may be important constitutional principles of the president's inherent power in Article 2, is that to tightly fit the statute to the operation would involve persuading and therefore telling a great many senators what the program is in its operational details. Senator Specter has suggested having the FISA court be the one. Go tell FISA, and they'll give you some kind of a group warrant or an open-ended John Doe warrant to go and do likewise in the following kinds of searches without having to go back to them every time. That is probably outside the Article 3 power of a judge. At least it's not been the way we thought of warrants in the past. So I think if there's going to be a legislative compromise, one of the likelier ways, in fact, is to have a reporting requirement, either to the Big Eight or to, in some kind of highly compartmentalized way, the intelligence committees. It's what the ultimate compromise was on the Lindsey Graham amendment on interrogation procedures. But I think it's going to, part of the problem with a net, part of the problem why my pension plan went south with my tech stocks, is it's very hard to anticipate how electronic communications are going to evolve, even within a month-to-month circumstance. So to try to fit this to a dynamically changing technology, which is extraterritorial, is going to be exceedingly difficult. Even the proper name Al-Qaeda is difficult. I mean, terrorist groups morph. You can get around it with associates of Al-Qaeda, but what happened if you had another group that was international, but was also thought to be interested in the same kind of catastrophic harm? Would you make it a proper name statute, or would you simply say that, try to frame it in terms of the kind of activities and the kinds of harm? So it may well be. If no one reads this book anymore, it's a great book. I recommend it. Charles McElwain on the ancient Constitution, but he makes this distinction between governance and jurisdictio and governance. That Congresses or parliaments tend to legislate in regard to things that admit of long-term solutions, whereas the executive, or in that case the royal power, is thought of as being what you need when it's again a kind of a dynamic circumstance where you can't anticipate in advance the iterations and permutations that will obtain.
If I could respond. First of all, the notion that we face a truly catastrophic threat today, but didn't in 1978 when we faced the world's second most powerful superpower, which had thousands of nuclear missiles trained on every one of our cities. We didn't face a catastrophic threat then? Sure, we faced a catastrophic threat then, probably a greater threat than we face with respect to Al-Qaeda today. But certainly not categorically different and therefore requiring an entirely different rubric. Secondly, when I listened to what Ruth said in response, I understood her to be making two proposals. A reporting requirement. FISA already has one. It requires a reporting every year to the Intelligence Committee of the number of taps, of the nature of the taps, of the outcome of the taps, and the like. Second, she said, well, we shouldn't use names for terrorist organizations because what if we have a terrorist organization that morphs? The FISA doesn't use names. FISA defines a terrorist organization as a group of two or more people who engage in terrorism, which is very, very broadly defined. So that is not a problem under the current law. So the two proposals that Ruth has made are unnecessary because one is already in the law and the other is based on a misunderstanding of the law. Let me talk about what FISA permits, because I think that helps you understand what we might need in terms of changes. It permits any electronic surveillance that is collected abroad and targeted at people abroad, without regard to warrants, without regard to probable cause, without regard to any standard whatsoever. So right now the NSA can listen in on every phone call of every person coming out of Afghanistan, Pakistan, Iraq, etc. FISA doesn't even touch that. Secondly, when and only when information is acquired in the United States or you target an American person within the United States, then FISA kicks in. And then it allows you to listen in on anyone who is a member of a terrorist organization. You just have to show that. Show that the person's a member. Shouldn't you have to show that? Ruth, in her opening remarks, said, well, maybe probable cause is too high a standard. What's interesting to me is that the administration has said that the standard they are employing under this program is probable cause. So they, apparently, the people who actually know the facts, who have made the decision about what national security requires, have said probable cause is okay by us. We just don't want to have to make a showing to a judge. But if you have to make the showing of probable cause, and you have to satisfy that objective criteria, what's the problem with showing it to a judge, unless, in fact, what you're doing is saying that you're applying probable cause when, in fact, you're not? Now, I think there could well be arguments that that we might want to reduce the level of suspicion that's appropriate when someone is thought to be connected with the enemy during a wartime. But again, the proper way to do that is to ask for FISA to be amended. There was a legislative moment. It was called the Patriot Act. The President asked for lots of changes to FISA in the Patriot Act. He got them. But because he thought he couldn't get this one, he decided to ignore the Patriot Act and violate a criminal statute. That's not the way democracy works.
All right.
Just a real quick repost, which is a point of so no one walks away from the Cold War quite so easily, on the issue of catastrophic harm. In the Cold War, mutually assured destructive capability, that haunting phrase from Dr. Strangelove. The Soviets knew we would strike back if they struck us. Deterrence worked, and we knew who the adversary was. There's no return address in regard to al-Qaeda, and therefore you have to anticipate things before they happen, which is an extraordinarily difficult task.
All right, Senator Adler has the final question of the day.
Thank you, Senator Scharf. Professor Cole, earlier you a few moments ago you said that there may well be portions of the executive's commander-in-chief power that are beyond the scope of Congress's direct regulation. Is there any doubt that, in fact, there is such a core of the commander-in-chief power, and can you give us some idea of what that core might be if it does not include surveillance of potential enemies?
Well, as I said, I think all the clause says is the President shall act as Commander-in-Chief, has the role of Commander-in-Chief pursuant to a war that the Congress has authorized, governing an army whose rules and regulations Congress sets, not the President, using whatever army Congress gives him. So it seems to me that the clear structural framework of the Constitution was we don't want to give the President a lot of power as Commander-in-Chief, but we do want to have a unitary source of authority for fighting the war. So, as I suggested earlier, if Congress violated that principle by putting someone else in charge or putting someone in charge of some aspect of the war who is not subject to the Commander-in-Chief oversight, then that might well be a violation, just as in Boucher versus Sinar, taking away execution of the laws and giving it to somebody who was answerable to Congress was a violation of separation of powers. It seems to me that certain kinds of micromanaging of battlefield tactics might well be seen as within the core, but I don't think that issue is ever going to arise because I don't think Congress would ever seek to regulate that. But certainly, so I think you could imagine certain situations that were within the core. I don't think warrantless wiretapping of Americans without congressional authority or judicial approval is one of them.
We've already heard several mentions, Professor Cole, of the 2000 Moss Memorandum that said the President's authority over national security and intelligence would enable the President to violate Title III of the Omnibus Crime Control and Safe Streets Act pursuant to that authority. Was the Clinton administration wrong in that memorandum?
I think it's a very different situation. What you're really talking about there, what was at issue there was the grand jury secrecy provision, which says that you're not allowed to disclose information that you obtain through the course of a grand jury investigation, and that it's a crime to do so. And the argument of the Clinton administration, at least as I understand it, was that for two reasons it doesn't really make sense to apply this to the president. The first is that, of course, the president is responsible for prosecuting the laws. He's ultimately responsible. So when his prosecutor happens to be in there, in the grand jury room doing the investigation, he is the president, right? He is the alter ego of the president. So sharing that information with the president is not a violation of the statute. It shouldn't be understood to be a violation of the statute. There's no indication that Congress intended the statute to prohibit that kind of communication. What it was designed to prohibit was public communication of the secret goings-on of a grand jury. And so this is a statute which could be properly interpreted not to apply to that kind of communication, at least where you're talking about a national security concern that is the president's constitutional duty to respond to. The difference here, of course, is that there is no argument that, in fact, the administration has not even suggested, I mean, given the arguments that they have made, you'd think they might make this argument, but they have not even made this argument because it's so ludicrous. There's no argument that FISA is not intended to prohibit warrantless wiretapping of Americans for foreign intelligence purposes during a war beyond the first 15 days of the conflict, because Congress made it very clear this was about regulating the president's wiretapping. They specifically addressed the question of warrantless wiretapping during wartime. They specifically put a limit on it, and they made it a crime. That's very different from the grand jury provision, which I think can reasonably be understood, not to prohibit the president's alter ego from sharing with the president the information that is at issue when national security is
really briefly, I have the memorandum
I'm
in front
sorry,
of me. It says that Title III cannot constitutionally be applied to preclude such disclosure. Is not that an argument that, in fact, the law would be unconstitutional insofar as it prevented the president from exercising his authority in this way?
Yeah,
and is that not the argument that at least Senator Roberts has made against FISA?
Yes, that is the argument, but it seems to me it's a very, very different context when you're talking about a general statute which is not, which there was no evidence that it was intended to preclude the president from talking to his inferior about the information that the inferior is acting on the president's authority in prosecuting, whereas there's every bit of evidence to indicate that this statute was designed to directly regulate this the president's authority, and I think under the Jackson analysis, the president's action is at its lowest ebb. I don't think the president's action was at its lowest ebb in the Rule 6e context.
All right. Before we go to the Q&A from our audience / members of the press, let me just take a pause to thank my esteemed senatorial colleagues and the two witnesses for their time today. If you would like to ask a question, we need you to wait for the microphone to be passed to you, since this is being broadcast abroad. And when you get the microphone, designate who your question is to, and please keep your remarks very brief. All right, back there.
Professor Cole, I have a question for you, actually. Back to the division of powers issue, you had mentioned that it would be unconstitutional to delegate a portion of the commander-in-chief authority to somebody else. But my question is, doesn't it sort of do that when you're delegating the ability to gather intelligence to a FISA judge? That's sort of taking that authority away from him.
That's a good point, but I think the response to it is that there are a myriad of statutes that restrict the president's ability to run the war, and FISA is one of them. Another one is the Uniform Code of Military Justice, which says that there are certain things the president cannot order his people to do. You could say, well, that's an intrusion on the president's ability to run the war. No, it's a restriction on the means and methods that he is entitled to use. The same thing is true of the torture statute. The same thing is true of the McCain Amendment. They are restrictions. They don't seek to appoint some person who's answerable to Congress to run the war, as Congress did with Boucher versus Sinar, where they sought to appoint effectively the Comptroller General answerable to Congress to execute the balanced budget amendment. And so I think that's the difference. It's permissible to put restrictions, and this puts restrictions. It's permissible to make those restrictions enforceable by courts, just as, for example, the habeas corpus restriction on the detention of enemy combatants is enforceable by courts, according to the Supreme Court in Razul and Hamdi. So if you took the broad view that what the commander-in-chief authority means is that nobody can intrude with a decision by the president about how he runs the war, then Razul would be wrongly decided, Hamdi would be wrongly decided, the habeas corpus statute would be unconstitutional as far as it extends to that, FISA would be unconstitutional, the UCMJ would be unconstitutional, the torture statute would be unconstitutional, and the McCain Amendment would be unconstitutional.
But if I may, David likes to talk about the Steele seizure case, which is a great case. Many of us read it as an anti-UN case and somewhat of a period piece, because a war by the UN or on behalf of the UN was seen as not quite admissible in some circles. But let me just remind him of a few other cases. Dames and Moore against Reagan says that if a power has been permitted to the president in some circumstances, you can draw an analogy from that and put it in like circumstances. Dames and Moore says institutional practice matters a great deal, particularly in separation of powers. And if it's the case that George Washington and Abraham Lincoln and Woodrow Wilson and Franklin Roosevelt and Harry Truman all engaged in unwarranted, unjudicially approved wiretapping where they thought the battlefield was an issue, you might wish to draw some kind of competence conclusion from that. You shouldn't forget about Curtis Wright, which reminds us that the president is the sole organ of foreign affairs. It's commander-in-chief, not corporal-in-chief. And David would have it be a corporal who can only act to carry out the edicts of the Congress. I mean, the question I'd put to David is, if Congress said that before you can target an enemy target in a foreign battlefield, that because we care about collateral damage, we care about human lives, we have human rights values that are universal, therefore, before you can target an object in a foreign war, you have to go to a court, a special court, we'll call it the Foreign Targeting Review Court, which doesn't make a very easy acronym, and you have to persuade a federal judge that your target is sufficiently grounded in a factually persuasive predicate. Would that be constitutional? Surely not. What's the difference?
Well, here's the difference. I think that's a kind of a Boucher versus Sinar situation. Here we're talking about...
No, they're not answerable to Congress in the particular decision. Congress is requiring delegation of commander-in-chief authority to an Article III court.
About the appropriate target. Well, it seems to me if I'm not sure that under rules and regulations of the military, Congress couldn't, in fact, pass a statute, for example, that said the military cannot engage in torture. And if the president let me finish. Can I finish? And if the president has a question about if the president has a question about interrogation practices that he believes.
Just do my targeting. Just answer my targeting question.
If he believes that a particular practice does not constitute torture, for example, because it doesn't inflict the pain associated with organ failure or death, then he has to go to a court and ask the court whether this is permissible or not before he imposes this. And similarly, we could have a law that says you may not target innocent civilians where there's no evidence that they are involved in the conflict at all. Not a question of collateral damage, but targeting innocent civilians. It seems to me it would be perfectly permissible for Congress to make that enforceable through the courts, either post hoc or pre. So I think I come back to the fact that you look at the framers of the Constitution and they said, we want Congress, not the President, to decide whether we go to war. We want Congress, not the President, to decide the scope of the war. We want Congress, not the President, to set the rules and regulations for the military. We want Congress, not the President, to define offenses against the law of nations, which include the law of war. We want Congress, not the President, to create and fund the military. We want Congress, not the President, to decide how much funds should be spent and for what. And so I think it's a mistake to think that the three words commander-in-chief somehow override Congress's ability to regulate quite extensively how we go to war. I don't think Congress is going to do that in most instances because there are obvious advantages to having a unitary command. But I think when there are serious countervailing concerns, like not engaging in torture, like not engaging in cruel, inhuman, and degrading treatment, like not invading the privacy of Americans without any justification, there it's perfectly appropriate for Congress to step in and regulate.
If Congress said that you couldn't hit a military target that could cause some collateral damage without having a court decide whether the collateral damage was reasonable, surely that would invade the commander-in-chief
Let's
authority.
move on to the next question. Did you have your hand up, sir? Yes.
Yeah.
Hold on. The microphone is coming. There.
I like Professor Wedgwood's skipping stone metaphor, and so I'd like to address my question to David Cole. Let's say we had that incident, and it took place 9/8, and it was a message to the other participants that 9/11 is D-Day. What is your response to that situation?
Well, my response to that situation is that the law would permit us, where we have evidence that a person is an agent of a foreign power, to listen into a conversation. In fact, we knew that there were agents of al-Qaeda in the United States. The NSA knew. We knew that they had threatened to attack us. We knew that they had attacked the World Trade Center before. We knew that they were taking flight training classes and the like. And even with all of that information, we didn't act. Now, would we have somehow acted more effectively if, in addition to that information, we were inundated with a huge amount of information? Because it was gathered through a much lower level of probable cause or individualized suspicion. What happens when you reduce the level of suspicion is that you greatly increase the amount of information that comes in, right? That doesn't necessarily make you connect the dots more effectively. I would like to put into the legislative record a recent part of Jon Stewart's Daily Show called Rampant Buggery, which was about the NSA program, and I think really sheds quite a bit of light here. And here's what he said. He quoted the White House spokesperson as saying, the purpose of this program is to help us connect the dots. So he said, well, that's interesting. What were the dots we had before 9/11? And he listed those four things that I said. Osama bin Laden targeted us. They went after World Trade. We knew that their people were here. They were taking flight training. And there's a straight line between those four dots, right? Then he says, what happens after the NSA program? And the whole screen fills with dots. And he says, and then he quoted the FBI, the story in which the FBI said that what happened with the NSA program is it generated thousands of leads that led to innocent Americans and dead ends, not finding terrorists, right? And he said, well, actually, if you step back and you stare at those dots long enough, you'll see a unicorn. And in fact, a unicorn. So I'd like that to be part of the record.
We have time for...
Just an important point. I wish life was as funny as Jon Stewart. On a good day. Moussaoui the laptop was not looked at because even though Moussaoui was doing funny stuff, you couldn't show he was an agent of a foreign terrorist network or a foreign power or foreign state. So there are instances where this predicate has been quite fatal. Two of the hijackers were getting phone calls from Yemen. It would have been interesting to see if you got the incoming Yemen call, who were they calling and who were they calling? And link to link to link. Linkage is very different from probable cause in any orthodox understanding. So yes, of course, you want a filter and a method of getting the good dots, not the irrelevant dots, but David wouldn't have any dots.
No, all right, that is not true, and let me just respond real briefly.
Professor, we need to start to close up, so one final...
Let me just, because otherwise I'll respond to the question by saying this. I might as well say it now. The 9/11 Commission looked at the Moussaoui case.
I waive lunch.
The 9/11 Commission looked at the Moussaoui case and found that he did, the evidence they had did meet the FISA standard, but they didn't go to the FISA court. Number one. Number two, the
Why didn't they go to the FISA court?
hijackers in the United States, who we knew were here, we knew were members of al-Qaeda, could have been surveilled using FISA. We didn't use it. So if we didn't use it where we knew that these people were members of al-Qaeda, what's the likelihood that we would have done this, skipping rock thing and somehow found them when we couldn't find it, when we knew the people who were here and were plotting to attack us?
All right. No, just hold up, everybody. We have time for one last question. We have a very entertaining, if not disciplined, group of experts. So let's have someone from way over here. Can you bring the microphone down?
Thank you. This is directed to Professor Wedgwood. I find your arguments to be far more political than legal in their basis, and with that in mind and three other factors, I'd like to pose this question to you. First of all, General Michael Hayden has said that the reason why they didn't go to the FISA court was to reduce the standard from probable cause to what he called reasonable belief as defined by some military official. Second point, NSA is doing data mining, which we all know can get real big, real powerful, real fast. Third point, just those 2 points, because I forgot what the third one was. But just those 2 points. My question to you is, under your theory of commander-in-chief, realistically, the third point is...
Is he middle-aged or what?
This president is setting us up for a situation where we're going to be in a war for a very long time, maybe in perpetuity. Where does this stop under what you're espousing?
Well, a couple of things. One is I don't think it's a political point to say that it's one of the most fundamental nostrums of statutory interpretation is to avoid close constitutional questions. That goes for civil liberties. It also goes for separation of powers. And to say that prior presidents, prior assistant attorneys general in the Office of Legal Counsel, prior Supreme Courts have interpreted statutes to avoid constitutional questions. That's one of the beauties of having a Supreme Court that's part common law court and part constitutional court. So to say that you should read a statute in ways that might seem absurd in constitutional terms, I think is not it's bad politics, it's bad law. So I certainly, I don't resent, but I do reject your implication that these are political views. These are views, I guess, informed by a deep appreciation that separation of powers is not simply a formal, interesting, aesthetic inquiry, but one that has great, great implications for the ability to respond to a very real threat. Now, if Michael Hayden meant probable cause and reasonable belief to be different, and it's not quite clear what he meant, but reasonable, if you look in the Fourth Amendment, you'll see both phrases appear. Obviously, it says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So reasonable, unreasonable is not outside the locutions of the Fourth Amendment. Probable cause enters into it because usually we get warrants, and usually they are based, therefore, upon probable cause. But if, in fact, General Hayden meant less than probable cause, well, you're a better brain reader than I am. That is simply my linkage point. You may have a very legitimate reason in wartime to need to surveil people as to whom you don't have probable cause. If you're going to preserve the robust criminal sense of what probable cause is, it will become an operational standard that's very, very difficult. On data mining, there are lots of different kinds of data mining. Your credit card company does a heck of a lot of data mining. Amazon does data mining. Google does data mining. One of the issues that's open for discussion is to what extent should you deny the government access to commercially available information. And that's a different conversation. But if this program was, and we have had no indication it is, but if it was data mining in the sense of a big ear in the sky that listened for the word thermonuclear device within 25 of Kandahar, within 25 of New York, query whether indeed the president shouldn't have authority, doesn't have authority to pursue that as a predicate. Data mining is abusive if it's based upon politically invidious characteristics or if it's used for the wrong purposes. And I take your point. Every kind of power can become abusive. But so too, I think, a exaggerated account of the degree to which wartime power can be delegated or carved away from a commander or corporal in chief to give it to the courts equally can become abusive. I mean, again, nobody wants a result in which there's a catastrophic event. Nobody wants a result in which Americans don't feel that their private lives are being respected. And the pragmatic and legal judgment and the political judgment that has to be made is how to balance the two.
David, I'm going to give you 30 seconds to respond or comment.
Well, first of all, let me say that my favorite professor in law school always used to say, I've got 3 points, and you'd write down 1, 2, 3, and he never got to point 3. So you're in good company. But I think your third point is actually, which you did revive, is the critical one, which is that this is a long-standing struggle, indeed one that we are likely to see throughout our lives, and that only underscores the importance of going forward in a coordinated and united front fashion. And that I think the way you do that is by acting pursuant to law and changing the law when it needs to be changed, rather than ordering that the law be violated in secret. And I think that's why 4 Republican senators on the Judiciary Committee, Senator Brownback, Senator DeWine, Senator Specter, and Senator Graham, all expressed grave reservations about this program, about the asserted authority for the program. Senator Specter said it defies logic and plain English. And as Senator DeWine said, we are stronger if we go forward in a united fashion. I wish President Bush had realized that at the outset and sought the amendments that he believed were necessary. I don't think we'd be in the situation we are today if he had.
Now, there is going to be a cocktail reception for the next hour so that you can ask follow-up questions. I know so many of you have them. But I want to thank all of you for coming to what has really been an extraordinary program. Thank you.
Well, I'm not as good as Snow.
Oh, you can try. I know. Well, it's got a heavy hand. It's actually only one person. Yeah. Remember, you ceded your time. I never got to finish mine because they went off on. Yeah, I did. I cut my time short.